a lot of people think of advanced directives, living wills or durable powers of attorney for healthcare decision making, or as they're sometimes framed, just surrogacy documents, as a kind of panacea. After all, it's a way of speaking to the future about what you'd want, extending into the future what you might say if you were unconscious and unable to make a decision. And it's easy to see how they can appear that way. For the purpose of the class, I'm going to take a contrary position. As it happens, it's the position I hold and have written about, but it's a contrary position that perhaps needs to be made as strongly as it possibly can, for two reasons. One, because most clinical ethicists, chairs of ethics committees, and indeed most hospital administrators believe that the more advanced directives are distributed to patients, the better. That is, if you can get people to come into the hospital and express what they would want, then in near end-of-life or end-of-life situations, that document, when it's pulled out, will resolve uncertainty. And the second is that there's a general belief in society that we are lacking in power in the healthcare world, and that perhaps if we could just recover some of it when we are at our most vulnerable, that we'd be in a better situation. And so this is a kind of a first stab at turning healthcare, which is already, as everyone knows, a marketplace in a number of ways, consuming a huge amount of our GDP, into a market that favors the consumer. Easy to see why this would be popular. But tracing the history, I think, reveals the origins of this way of thinking, suggesting that perhaps we're a little too optimistic, or as I'm ultimately going to suggest, that advanced directives don't work, that living wills are a nightmare, and that it is irresponsible to provide patients with advanced directives with any kind of encouragement that by filling one out, they'll actually be putting themselves, their family members, or others into a better situation. That's pretty plain spoken. The history that's often told, and that my colleague Sheila Otto has told you, has to do with the case of Karen Ann Quinlan in New Jersey. A case that, as you've heard, involved a young woman, and these cases typically do, who was brain injured after being face down in the water and ended up in a persistent vegetative state. And if there's anybody around the world at this point who doesn't know what a persistent vegetative state is, I haven't met them. Later, the case of Nancy Cruzan occurred in Missouri. And the Nancy Cruzan case is really the pivotal one. Just like Karen Ann Quinlan, it was an automobile accident, or in her case, a motorcycle accident. She spent about 12 minutes face down in a pool of water. When she was resuscitated, it was possible to get her to the hospital. To make a long story short, over the course of several years, legal wrangling ensued about whether or not Nancy Cruzan had really ever expressed what she would want to have happen if she were in a permanent, eyes open state of unconsciousness. She was tested up and down with all kinds of scans to determine whether or not she was really in a coma, the kind of coma from which one either dies or recovers, to determine whether or not she'd been misdiagnosed. Maybe she was just locked in and could in fact wake up. Tests to determine whether or not there would possibly be therapies that would help her at some point in the future. Ultimately, the decisions of all of the clinical staff involved basically amounted to there's no way. Patients with persistent vegetative state, I should say by way of background, have lived as long as 33 years, 111 days. So Nancy Cruzan, as a very young woman, had a long future ahead of her, potentially, in which, with the feeding tube that she had implanted, unlike the respirator in the case of Karen Ann Quinlan, she could conceivably have lived for a very, very long time, and her insurance having run out after about a year and a half, at considerable cost, a factor that, when it isn't brought up, looms outside the discussion. So what happened? Well, John Danforth, a Republican from Missouri, initiated debate in the House of Representatives and brought that debate at the time when the resolution was being debated for the new budget. So in the Omnibus Budget Reconciliation Act of, I believe, 1989, yielding in 1990 a variety of new projects, Danforth on the basis of a couple of really important speeches, argued that we needed to have an unfunded mandate to the states. The states would receive no money for it, in which the states were required to create policies so that every person in every inpatient or outpatient setting would be told that they could get an advance directive, that they had the opportunity, the right, to be given a piece of paper and have it explained to them and then have the chance to sign it before anything else happened or at any point during their hospitalization. And the critical piece for me is that Danforth gave a speech, it's not often remembered, in which he said that the point of advance directives was to give a Miranda warning to the young people for whom the most frequent cause of death is automobile accidents, so that if they didn't have advance directives, as Nancy Cruzan did not, they'd think twice and perhaps get them. And Miranda warning, very strong kind of language, appeals to the young people who are also the most often arrested criminals, right? But the language says something else. It says that not only do people have the right to make their own health decisions, but if they haven't chosen to plan in advance for those health decisions, then we can kind of hold them responsible. Now, the case, which you'll read some about, ultimately has a kind of bizarre roller coaster history. The Supreme Court ultimately upholds the Missouri Supreme Court's decision, which said that there needed to be at least 3 people who would emerge and say, yep, Nancy Cruzan actually meant what it's been alleged that she said. She really did, it's been proven, say that she wouldn't want to be in a persistent vegetative state. That's not so much what matters. Famous case. What matters is that the Patient Self-Determination Act was passed as part of the Budget Reconciliation Act. It took about a year and a half before there were actual rules, the so-called regulations that are issued to govern that law, during which time a lot of people were very confused about how to implement it. And around the United States, hospitals, as I've said before, began to implement new forms of in-house regulation. They created ethics committees because you had to have one under the Patient Self-Determination Act to deal with an advance directive when it went wrong. They created all kinds of mechanisms. So here we are now, more than a decade past the Nancy Cruzan case, just coming out of a nationwide and indeed worldwide debate about Terry Schiavo, another persistent vegetative state patient, and with on the horizon possibilities that the Swedish and Swiss and of course those in the Netherlands will pass a long and really with great history, a long cascade of new rules about who you can release from this mortal coil on the basis of their beliefs about end-of-life care. What do we know? We know several things. First, on the basis of one of the largest studies ever, if not the largest study ever, of end-of-life care, we know that even when patients have advance directives, and even when nurses are brought into major medical centers to help the patients think about, or to help their families think about whether or not they mean what they wrote in advance directives, that conversation has no bearing on outcomes. Or let's go one step further. Another large study proved across a pretty good-sized cohort of patients that advance directives themselves, whether living wills or durable powers of attorney for healthcare decision-making, had almost no effect at all on whether or not the patient received what was requested in the advance directive. Now, why would that be? Right? Why would we, with 10 years of history, 10 years of time to adopt a good advance directive policy, not have gotten there? I think there are 3 reasons, and I want you to consider them as we read and think this week, and more importantly as you discuss with each other what you think an advance directive should or could do and whether it could ever work. The first reason I think they don't work is that they are, in effect, Chinese menus. This is true primarily of living wills, where in most states people literally check off, I don't want a respirator, or I don't want a feeding tube, I don't want surgery of any kind, and up to 25 options I've seen in living wills. And as they're checking these options off, they're put in a kind of a funny situation. Now, if you're very ill, you can imagine certain treatments that you wouldn't want. Jehovah's Witnesses write what are in effect advance directives. They are in fact advance directives, and they say, I don't want blood, period. Right? Most advance directives, though, require you to say in a very, very short form, which typically gets notarized and so on and so forth, what you wouldn't want. And the problem with that is that you can't know. And why can't you know? Because living wills hang on two critical features. One is a physician has to agree, they have to believe, to trigger the living will, that you are imminently going to die. So the living will doesn't come into effect until there is, in fact, this situation. You can create an advance directive that says, under no circumstances do I want X, Y, or Z, but typically we don't call that a living will. We call that a portable do not resuscitate order, and there are several states that spell those out. How could you know, right? So many cases involve living wills where someone has said that they do not want a respirator, but a respirator is precisely what they would need in the emergency room or the ICU to make them better. And so surgeons and doctors are left in great confusion because it's clear that the patient didn't mean to say, I would never want a respirator if I were dying. What they meant to say was that I wouldn't want a respirator under certain very specific circumstances, and they don't get a chance to explain them. Now, people have suggested other ways of documenting those wishes. Zeke and Linda Emanuel, in an article that I think stands out as one of the better articles about this, said, well, let's just have people fill out values histories. But when less than 1% of Americans in the highest risk category fill out even these tiny little living wills, the idea that you'll get a 21 to 27-year-old to fill out a values history that spells out how they'd want to die, where they'd want to die, or even just that they would ever imagine dying, well, it's near zero, right? So you take it from 1% to 0.5%, what happens? And that leads me to my second point. We do know one thing about advance directives, and it's terrifying to me, and that is that when people do not have advance directives in the contemporary healthcare environment, they are a little bit more likely than others who are in a comparable situation across a long period of time to receive more treatment than they would have otherwise. So to put a fine point on it, we do know that there's one effect that's been pretty well measured, and that is that advance directives as a phenomenon in our society have rendered the 99% of the people who don't have them more likely to end up stuck in an intensive care unit for a very, very long period of time. I mean, people ask on rounds, does so-and-so have an advance directive? And the answer is no, and so then they go full steam. You've seen it if you've been in a healthcare environment. It's actually begun to play that role. And then the third piece, which is the piece that I think is most theoretically complicated, and I want you to think about here the juxtaposition between the view I'm articulating and the one that Sheila has, is that I think there's really no place for a contract like this in the intensive care or other long-term or short-term hospital environment. I think we want to protect ourselves. I don't think there's anything wrong with thinking that we should govern our own health care. The question is, how can you do that? Right? People have advance directives because they're being seen by strangers and they don't trust them. And there's every reason for them to be afraid of the strangers who are taking care of them, even if they're the most well-intentioned people in the world. They want evidence there. But what they do is they preserve that evidence as a legal document. They put it in a safe deposit box. They have it notarized. They might carry around a copy in their wallet, but typically they don't. They think of it as, and they in fact usually download it as from some website, as a kind of codicil to their will. And the effect of that, of course, is that most of the time it's hard to get access to the document. Most of the time the document is out of date. And all of the time the document is subject to, I don't know how to put this, but interpretation. Right? So the living will, as I said, is always subject to the doctor's discretion as to whether or not they think you actually are going to die. And if they think you aren't, then that's the end of it. It's also subject to your whispers as you suffer. More than once, I've walked alongside a cart when someone said, no, I want to live. And that's it. You had to notarize it to get the living will, but if you whisper, don't let me die, it's gone. The third piece of that is that even for durable powers of attorney for healthcare decision making, which most people favor as a legal document, there's a real question about whether or not, no matter what you write down, when your family members show up, a physician is going to be able to take the side of a piece of paper written by, or maybe just even signed by, a person who's unconscious and weigh it more heavily against people with lawyers who are in the room, or worse yet, long distance, who say that they believe that the position that's written down is not the right one. Advance directives, living wills. They look like a solution to a very, very difficult problem, and that is people being able to express their wishes at the end of life. Is there an answer that's better than advance directives? I don't think anyone's really answered that question, although many suggestions have been made. What I want to address in this conversation, and what I hope you'll address in our discussion, is whether or not we really should be offering up advance directives in clinical cases, whether or not they really do ever help, and most important, whether or not introducing legal documents into a clinical setting ultimately hurts patients and physicians in a way that isn't obvious but is incredibly pernicious and dangerous.